Good afternoon, everybody. I'm Mike Siebold. As always, I'm being joined by my colleague and work wife, Jason Desentz,
Hello.
both advisors of FlowerHire. FlowerHire building a conscious cannabis community one hire at a time. Today, we are being joined by Brian Casaceli. Brian, thanks for having us. Please introduce yourself and tell us a little bit about your firm.
Thank you very much, Mike and Jason. It's a pleasure to be on with you both today. I am an employment lawyer based in Massachusetts. I work for about a 70 lawyer firm up here right outside of Boston. I practice labor and employment law, obviously a timely topic given our discussion today. And my practice consists of representing both employers and executives in all facets of employment-related law, specific to human resources issues, specific to litigation, and also on topic today, specific to restrictive covenants, including non-competes. So certainly looking forward to the discussion.
Oh, appreciate fielding what is obviously on everyone's mind in terms of restrictive covenants. The first thing probably is a little bit more of a backdrop and a context about non-competes, restrictive covenants, widespread across a number of different industries, technology, healthcare, professional services. Their enforceability, however, has always varied very dramatically in some instances by state, with some jurisdictions having pretty harsh and strict limitations to protect employee rights and promote competition. Now, with that as the backdrop, what happened recently in terms of the FTC ruling, and really, how does that change the historical context?
Yeah, it's a great question, Mike. And so for almost a couple centuries now, the law of non-competes and other restrictive covenants has primarily been governed by state law. And so consistent with your point, the states around the country each would typically have a common law that's pronounced by the courts governing the restrictions that an employer can put in place after an individual leaves their employment. Towards the end of 2022, however, the federal government got more actively involved, and in early 2023 actually published a rule that would largely ban the use of non-compete agreements. And as you can imagine, that was met with a significant outpouring of comments from all parties, both pro and for. And so over the course of the last year, the Federal Trade Commission, the FTC, has been evaluating the comments that it received in connection with its proposal to ban non-competes. And very recently, in April of 2024, has announced a rule that by and large, and we can talk a little bit about the specifics, has the significant effect of outlawing and banning almost all non-competition agreements, which is a significant change and reflects a departure really from their use over the past many decades.
Brian, having been in HR for many years, there's always been a little bit of confusion in many minds, the difference between a non-compete, confidentiality agreements, NDAs. Are all those synonymous, or are they different in some things? And what is it really, in your mind, companies are trying to protect?
Yeah, absolutely. And as far as when I use the word restrictive covenants, and it's a good clarification, Jason, there are several different kinds of restrictive covenants. So the one we're talking about here today are non-competition agreements, and those are really intended to prevent an employee from leaving their employ and going to work for a competitor, really performing the same or similar functions for the competitor that they performed for the prior employer. In addition to the use of non-compete agreements, you also have confidentiality agreements, which, as the name implies, are intended to protect an employer's confidential information and trade secrets. Bringing up the rear are non-solicitation provisions, and those really take two forms. One, a non-solicitation provision prevents an employee from leaving a non-solicitation provision prevents an employee who has left their employer from then going back and reaching out to customers with whom they may have worked, or about whom they may have learned confidential information during their employment with the prior employer. A non-solicitation provision can also prevent an employee from soliciting their former fellow employees or contractors with whom they may have worked at the prior employer. And so all three of those covenants really are intended to protect three primary business interests. The first is customer goodwill, which is the relationships that you develop with your customers and the reason why a customer keeps coming back to you. Two, confidential information. So you have that secret sauce, if you will, and an individual can't take that and go to a different employer and recreate that. Or you have trade secrets, which are a little bit different than confidential information and which carry, in most states, a statutory definition. And so those three restrictive covenants are generally aimed at preventing, at protecting those business interests that I just articulated.
So just thank you for clarifying that, because I think there's a lot of misnomers about those three. And with the new regulation, does that impact the other covenants, of non-solicitation as well as confidentiality, or is it just really impact the non-competes?
Yeah, so it is specific to non-competes, and I'll add a bit of a qualifier there. The FTC was careful to note that employers can still continue to use confidentiality as well as non-solicitation agreements, provided that those non-solicitation and confidentiality agreements don't have the effect of restricting an individual from working for a competitor or penalizing the individual from working for a competitor. And so often when I review agreements, and I see it's entitled a non-solicitation agreement, and it's intended to be structured as such. If you really get down into the nitty-gritty and analyze the terms, in actuality, it operates more like a non-compete. And so the FTC has made clear that in those types of situations where something perhaps tailored or tried to be tailored as a non-solicit may in fact be considered a non-compete, in which case it would be unlawful, and also you couldn't try and enforce it against an individual. But this is the sort of the pitch for companies that have those non-solicits and those confidentiality restrictions. Definitely encourage you to reach out to your counsel just to sort of get a second check to make sure that the language would pass muster under this FTC's ban.
Now,
Excellent.
this is not your legal opinion, but to me, it sounded like almost that the FTC proposal for banning non-compete agreements, in effect, extends itself to non-solicitation as well as confidentiality, because those latter two could be construed as a non-compete, which is not permissible. So this does effectively, in a sense, change maybe not the standing, but the interpretation of each of those.
And it depends upon, it's a fair point. It depends upon how they're written, right? If they have the effect of truly prohibiting someone from working for a competitor, then yes, I would think that they would run afoul of those terms. I do still think, and I sort of want to emphasize that there is a place for non-solicitation provisions as well as confidentiality agreements in the makeup of an employer's toolbox that it can use to protect its interests. It just needs to make sure that they are appropriately drafted and don't have the effect of what a non-compete does. So.
The other thing I was actually curious about, because a lot of people watching or reading this are going to say, how does this affect me? Right. Mm-hmm. So one of the interesting things is always, people see a ban on non-competes and then there's the fine print. And one of the things I'm curious about is we know that existing non-competes are unenforceable for most workers. However, there are exceptions. So what are those exceptions to non-compete, to you still being dictated by a non-compete that you signed?
Yeah, absolutely. So So I mentioned it at the outset, they largely, this ban largely invalidates all existing non-competes.
Hmm.
And the one carve out that the FTC put in its final rule, and this was something that it had developed after receiving comments from interested parties, was that for those non-competition agreements that are in effect for senior executives, those agreements will continue to remain in effect after the effective date of the non-compete agreement, which at this point in time, I believe, is September 4th. And so the question next is, well, what's a senior executive, right? And so the FTC's rule defines a senior executive as someone making at least 151,000 and change. I think it's 151,164. I have the number in front of me. Yeah, $151,164 during the prior year. And the individual also needs to hold a policy-making position. And that policy-making position, well, what is that? Well, the FTC says that it's the president, it's the CEO of an organization, or it's another officer who has really decision-making authority or policy-making authority over the business. Or any other individuals in the business who are similar to officers and who also exercise that policy decision-making authority. And I'll add here, folks may be thinking, oh, well, there's a fair amount of senior executives in my organization who, who their non-competes are still going to continue past September 4th. I would caution you, because the FTC's perspective is less than 1% of the workers in the country who have non-competes will qualify for that senior executive exception. And so it is, from my perspective, going to be very narrowly interpreted by the FTC. And so before classifying someone as a senior executive, you really need to dig down and just ensure that truthfully that this individual would satisfy the criteria and have their non-compete continue past the effective date of the ban.
That's the thing I'm actually curious about, because a lot of cannabis, there's no global consensus on how to grow cannabis. So, IP in the truest sense for some of these methodologies is maybe inaccurate, but a lot of it is going to be accurate. Some of these businesses have created and solved for with methodologies that are proprietary.
Mm-hmm.
That's for sure. This does, it sounds like the non-compete ban is not necessarily applicable to a very interesting arbitrary number of 100. If you make 151,164 and above, and a policymaking decision maker, as well as what is akin to an executive.
Mm-hmm.
One of the questions I had that was interesting, where it could be something that businesses look at and try to imply from, is the natural person element. So am I misconstruing that or misunderstanding that? Because some of these individuals will qualify. They won't be an executive, but they will have policy making decision making. They will have a salary band that is above that threshold.
Yep.
So is there something that is going to maybe be applicable when they're not a named executive, say if they're a director or a VP?
Yeah, it's a really good question. And the guidance that I have reviewed, and a lot of the commentators are taking the position that the language, the senior executive person is generally going to be, again, it's obviously fact dependent, but it's generally going to be the C-suite individuals, the individuals holding those positions, so CFO, COO, Chief Human Resources Officers, so positions of similar stature, and then as well as sort of 1 to 2 levels below that. Recognizing again that it is a fact-specific inquiry, I think you can and you may find individuals who occupy those positions, director level, for example, that would be considered to be, have policy-making authority. And I'll just clarify, and I have it in front of me because it's sort of unique text, that policy-making authority means having final authority to make policy decisions that over significant aspects of the business. And so you really need to get into the weeds, if you will. And that wasn't a pun, an intended pun, I promise. You need to get into it and really analyze, where things fall. Um,
Yeah, that's going to be intriguing aspect, because in cannabis, we find that they're a lot more leaner in the senior levels. Only in some senior executives actually do multiple jobs. So there will be, in my mind, some challenges, I feel like, coming in where some firms might say, hey, this person makes significant decisions and authority, and because they own operations, and they also own supply chain, and they also own, packaging on the cultivation side, which can be very, very, really a main part of the business. I'm curious to know from your perspective, we've talked about, let's say someone leaving and a non-compete, but what if, there's some rifts that occur, reduction in force, where severances are now being involved. Are you seeing any language that allows companies to still add that to the separation agreement as normally would be?
Great question, and in fact, it's something that I had thought about if that had been, or if that was something that would be permissible as a way to sort of get around the rule.
Mhm.
And what I'm reading is that that would not be permissible, and that the FTC has taken the position that even if you have agreements you give them severance, right, in exchange for their agreement not to compete, that would still run afoul of the FTC's ban. In similar regard, sometimes there are forfeiture for competition agreements, and so you can have, the individual, you can promise to provide this individual with, equity or whatever, severance, in exchange for them not to compete, or you can forfeit that and you can go compete. Those two seem to run afoul of the non-compete ban as well. And I'll just note that one of the things employers need to be conscious of here is that the FTC is going to be very strict and narrow in my estimation in their interpretation. And so if it's a close call, I think that more than likely, it would probably be construed against the employer and more restrictive than they would probably like.
Yeah, and that would make sense, right? It's kind of like an FMLA, right? Where it's, it's definitely protects the employee more than the employer, which makes sense. Same with this. It feels like how does, and I guess in your mind, maybe not obviously from a legal perspective, but an opinion perspective, what do you think some of the ramifications could occur if companies, kind of keep trying to push that though through the severances and get it through without FTC stepping in, so to speak.
Yeah,
they're not
I
necessarily
think
going to do that in Canada.
right.
Sorry to interrupt, but right?
Oh, no, not at all. I mean, to think that the FTC would be able to police, that's just simply not possible, right? Given their reach and whatnot. I mean, they could identify a few target cases and let the public know that it's an enforcement priority for them, but they're not going to be able to actively police, every employer out there if they're continuing to do that. And so, what you might find is um, civil litigation and individuals privately pursuing claims against employers. The other risk to the employer is, okay, I'm going to provide you this severance in exchange for your agreement not to compete. Well, if you pay the severance, right, and then you have the non-compete provision in there, and it's challenged, you're probably going to lose, and you're also going to be out, however much in severance that you pay them. So that would be, a fairly significant risk. And also there's the concern that, if they were to come after you for the FTC, they'll cite you for, even putting the non-compete in front of them for consideration. So that it seems to be an area that is fairly fraught with risk.
It'll be interesting in the next short while, because I know part of the obligation according to the FTC, the employer has an obligation to inform workers about the unenforceability of non-compete agreements. So in the short term, we're probably going to see people ask and know firsthand if these businesses are actually seeing that their contractual agreements are moot or not.
Yeah.
But more importantly, I mean, are we getting ahead of ourselves? There are still a lot of legal challenges from organizations, the U.S. Chamber of Commerce. Is the ruling by the FTC uncertain, or do you think it's likely to happen? Because
I
not
think
finished.
Yeah. So as I mentioned before, the effective day of the rule is September 4th. If, and that's the caveat I'll make, if there are legal challenges, Mike, that you referenced that are not successful, or that there's been no decision at that point in time, which I think is unlikely. And so, from my personal opinion, certainly not speaking on behalf of my firm or anybody else, but just my own, is that I think the legal challenges, and there's been three that I'm aware of right now, no decisions have been issued, but two in Texas and one in Pennsylvania, all in the federal courts, is that they're probably going to be successful, at least for enjoining the non-compete rule, and thereby not allowing it to go into effect in September. And so one of the things we're advising our clients, employer clients at this point, is to take a wait and see approach, at least for the next month, maybe month and a half, and then reevaluate and see what happened. Because by that point in time, it's very likely that we will have some further guidance from one of these court cases. I know the two Texas cases were one was stayed, and the plaintiffs in that case joined the other plaintiffs, and so it sort of consolidated the case, if you will. But I would expect to see some resolution on the issue within the next, I'm guessing here, but within the next month, month and a half, 2 months probably at maximum.
Wow. So it's in the near term, even though, your personal opinion is that it's going to maybe be held back, there are going to be obstacles. Ultimately, the ban is going to be enforceable and it's going to be in place. One of the questions I have about, as it pertains to cannabis, as a space, as an industry, with budding professionals and IP, and I would say a lot of institutions and businesses that believe that what they have created as the largest and first instance of recreational and medical cannabis does have IP, does have benefit that's not for public consumption.
Sure.
How do you think businesses, both institutional and budding early stage businesses, are going to approach talent? When you have less tools at your disposal from an HR perspective, potentially to protect the business and its IP, the other sorts of things that you can do to make sure that if there is something worth being protected about, it's something that can be protected correctly.
Yeah, it's a great question. And I'll just clarify, Mike, just to make sure my prior answer on I ultimately think it'll get struck down. I think it will get struck down in its entirety. I think that the FTC exceeded its authority in order to enact it. And I think that there will be successful challenges to it. And I think it's something that Congress probably will need to do if they really want to, but not to politicize anything, but it's difficult to get anything through down there these days. But just to answer your follow-up question, it is a delicate tightrope that you want to walk there. And so in addition to the restrictive covenants that I would strongly recommend businesses put in place, and the confidentiality and the trade secret protections, as well as non-solicitation agreements. And I would ensure that they're, narrowly tailored to specifically non-solicitation agreements, narrowly tailored to apply to those customers with whom the individuals may have been worked, or about whose confidential information they learned, and so they can't leave and then, start going after them. The confidentiality piece, I would be explicit in the agreements, without obviously disclosing, the specifics of the confidential nature of the information. But I would be as clear as to what you are specifically protecting, what you as an employee have an obligation to maintain the confidentiality of. I would. Just in general, as a good business practice, is to have policies, outside of employment agreements or restrictive covenant agreements, that govern confidentiality of information. I would try and set parameters to the extent it's reasonable and appropriate as to who, has access to the information while you are, while you are employed. And I would also, encourage employers to take solace in the fact that, in addition to any agreements, you have at your disposal fairly strong protections under state and federal law for trade secrets and confidential information. And so, in a worst case scenario, someone absconds with your confidential information, you have the ability as an employer to pursue injunctive relief against the individual under state law as well as the Federal Defend Trade Secrets Act, which was a law that was passed back in 2016 that most likely would come into play too. So, I think businesses they do have a fair amount of tools at their disposal, when trying to protect their interests and also recruit talent at the same time.
Well, no, that makes us feel great. And selfishly plugging our own services, Mike and I do a lot of handbooks for companies, and we always make sure that confidentiality agreements and non-solicitation are all in there and are pretty solid. Understanding that non-competes can be a little bit tricky area for companies, and we try to avoid those unless we have to do it, and put them more of an employment agreement versus necessarily in the handbook per se. I'm curious to kind of learn if it's struck down. One of the things that Mike and I coach a lot of our clients on is, cannabis is a big trust industry because of the nature of its, origins. It really is one where cultures are built on trust. Mm-hmm. So a lot of the gotcha culture where, non-competes were used maybe all the way down to the hourly employee, it doesn't go well. And, right. We try to coach and guide a lot of our clients not to do that. In your mind, if it's struck down, what would you tell? I know we kind of talked about, decision authority, but if you had to put like title on it, like director and above, VP and above, what would you tell a client that would say, hey, here's probably the level you could probably consider non-competes and above, rather than going from C-suite down the other way, go from bottom to the top?
Yeah, absolutely. And I just to take my home state, Massachusetts, as an example, we're one of the states who put a law in place about 6 years ago now that's put certain terms and conditions on an employer's ability to use a non-compete. And one of those is that the individual has to be classified as exempt under the Fair Labor Standards Act, which implies a fair amount of, depending upon which exemption is being used, which implies a fair amount of responsibility, under the circumstances. And so, just to answer your question specifically, though, Jason, I think probably director level, jumps to mind as a way, or as a potential position where I think that there's a real benefit to an organization from for using a non-compete. And again, that's not to say that you don't have a managerial position who might have access to that, the secret sauce, to bring back my prior reference. Who needs that, and who you don't want going to a competitor and disclosing that information, performing the same services. But I think as a general rule, a director level is appropriate and reasonable. Certainly not the rank and file. On those who get struck down, they wouldn't even be allowed in most states, or in some states, I should say. But good question.
Thank you.
With the ban potentially being struck down, in your opinion, but with the FTC attempting to institute the ban in the first place, do you think that there's going to be a renewed effort to try to strike it down in a separate way?
So I think that you're going, as long as the FTC tries to, and this is my personal opinion, as long as the FTC tries to continue with these efforts, I think they are going to meet significant resistance from the business community. And that's not all businesses, certainly, but I think, the Chamber of Commerce obviously is leading the charge in this particular case. And there are some businesses in specific industries who are, very, they favor the use of non-compete agreements. And so from my perspective, if this really is something that you know that the government or the White House wants to get done, as much as painful as it will be, it would seem that the route that they have to take is through Congress. They may, and I don't profess in any way to be a government expert in strategy or whatnot. Perhaps they could try again with the FTC and maybe put in place a more narrow restriction that wouldn't result in them receiving the same type of arguments that they're getting now as exceeding their authority and that it being arbitrary and capricious. But I just think it's something that's probably left to Congress. And I think if you did get something through Congress, if obviously, it would probably withstand the challenges that are being levied right now.
So the ban is not happening effectively.
I don't. My own personal opinion, I think that it's I think it's got a I think there's a pretty strong likelihood that it's going to get struck down.
But what I did hear, which is nice, in your opinion, is kind of what we're suggesting to our clients as well, is really kind of similar to Massachusetts. It really should start with at least only exempt employees, and then even furthermore, director possibly and above, or someone of significant status like a manager, like single contributor. Like in some cases, that could be cultivation growers or those that work in the kitchen, so to speak, culinary areas of cannabis, because those are unique roles. And I can see those. Or in other industries where I've seen a lot of them really being used as sales, right? Because your client relationships are really, that's really where a lot of them are. In some cases, when you leave, you kind of take that relationship and how that's kind of a tricky one. How do you see sales? Really, is that still the tricky one in your mind? Because to me, CEO is different than sales. So I mean, I'm curious what your thoughts are.
Completely. The thing with sales too is, you have that's where really the non-solicit comes into play significantly, right? And so, if you go and work for a company in the same industry, right? Let's call it biotech, just as an example, right? And you're working for a direct competitor, and John Smith, who you just worked with at this vendor or this company. What's to stop you from picking up the phone? You need, in my estimation, that's something where there's a real value of non-solicits. The other thing too, that sometimes you run into is the goodwill argument, and who does the goodwill belong to, right? And if we even get it down to a different level, so like a financial advisor, for example, if they come on board and they're attracting the goodwill of the customer, or the client, and then they leave and the client follows, who does the goodwill belong to? Is it the company, or is it the sales or the financial advisor? The same thing with insurance brokers, right? Is it theirs, or is it the company's? And so that's a calculus that the court would have to take into consideration, and if ever challenged. But sales is a creature of its own. It's a it can be litigious too when things go awry.
I'm actually curious also on your thoughts. So we were actually supposed to speak this time last week, and then days after our original meeting, the president came out and talked about the process by which cannabis is going to be rescheduled from Schedule 1 substance to Schedule 3 substance, and talking about putting the weight of the White House behind that effort. So officially, in every respect, there is a catalyst. Cannabis is fundamentally in most ways not going to change, but consequently in a few specific ways, it's going to change enough to make a very abrupt change for everyone included. I'd be curious. This is actually a good opportunity to talk about your firm and your work within the cannabis space. Equity and the value of these businesses is about to precipitously change, right? It's not a guarantee that they're going to be successful, but the way that they're going to be able to appropriate capital, and by virtue of that, their growth trajectory and their equity should go up for categorically pretty much everybody.
Yeah.
So by virtue of that, you're going to have the first instance of both businesses, new and old, looking at the value inherent to their business, right? What are the most important people? What are the most important functions? What are the most important methods that we have devised or created internally, but that we have perpetuated? Do you think, and has your firm seen activity or conversation about businesses being more methodical and thoughtful about production capability? Have you started to see cannabis businesses preemptively have that conversation because of this change? And should they start speaking to you if they're thinking about it for the first time?
Yeah, I haven't had the opportunity to have those conversations, Mike, and so I don't want to opine on just given the newness of the reclassification effort, and so I haven't yet had the opportunity to have those conversations. I think that your point is well taken. One of the things too, I suppose, given the increase in value of the businesses, given the reclassification effort, is to ensure that the companies are their equity related employment agreements and equity and stock provisions that they have are airtight, and that they're if they're bringing on new capital, or they're bringing on new investors, to have those types of agreements reviewed. I don't know where private equity will come. That's something you guys could probably comment on as to their involvement, and I'd be interested to hear your thoughts as to. But that's another consideration as well. If you're attracting, PE, there's a lot of hoops you got to jump through there. Those very very demanding firms, and so the stuff that you need to put in place. But I would be interested to hear your thoughts on that.
In terms of as it pertains to private equity?
Yeah, yeah.
Oh, yeah.
Well, prior to us putting on the recording, we were talking a little bit about how, fundamentally a lot of structural faults are not absolved in the space itself. So banking access we're still excluded from. Banking services by virtue of that. Credit card processing is still very much not central to our thesis. Interstate commerce, it's still federally prohibited. It's not been descheduled. So I think private equity will have more than a tepid interest in it, because some of these businesses are going to be financially alluring enough for them to maybe make a placement. But it's, has the gate swung wide, and is everyone going to buy everything up and basically collective make a Kraft Heinz situation? No, it's still categorically very early for that. Though I would say, and you brought up two important points that I think people listening to this or reading this should understand. Airtight equity agreements, right? That kind of programming, I would, in our experience, is often not airtight. So they should definitely call about that specifically. And then, following on to that was also the instance of, what was the second thing that you said other than equity arrangements? What was the second point?
Outside investors.
Outside investors. The investors that have been sidelined, so venture cap, family offices, people of that stripe, they have been sitting waiting for either an early stage participating company, an early stage marketplace like in Ohio, which starts next month, or they have been waiting for regulatory change at the federal level, much like this. So I think private equity investment, which is a size and scope that we really haven't seen much of, that's going to still stay on the sidelines, but venture capital, early stage seed investors, they're going to be actively involved. So I think it's even more important, people listening or reading this, to contact you as well, because cannabis has become much more intriguing from an investment perspective categorically for most of the participants, not the largest participants.
Yeah. Can I ask? Oh, go ahead, Mike. I'm sorry.
Well, I was going to say, and most importantly, how do they get in contact with you? What's the best way?
I appreciate that very much. My firm is Mirick O'Connell. You can shoot me an email at BCASACELI at MirickO'Connell.com, and I can provide the contact info as well. And my phone number also is 508-860-1478 as well. So.
And you had a
I
follow-up.
did, and I hope you and you could certainly edit this out if necessary. I'm actually really intrigued to if you guys think so. Obviously, the reclassification is a significant development. Do you ever foresee, and this might be the $1 million question, ever it being completely declassified at some point in time?
I do, not for some time. I think the thing that is important about the paradigm that we're in is who wins by virtue of us being a scheduled substance. So when you don't have interstate, you have to essentially reshore manufacturing jobs. States get to put onerous taxes heaped upon us constantly. Now that's alleviated somewhat, but states, by creating these licensing regimes, et cetera, they're the beneficiaries. Hopefully they're allocating that money to real needs within the state. Yeah, obviously that is always met with supreme skepticism because it's bureaucracy.
Right.
But it's how would I put this? Because it's a funny thing to think about. And we're not going to cut this out because it's too good and too real of a question.
I mean, sorry, go ahead, Mike. I have a thought on that after.
Go ahead. Let me formulate my answer for
All
you.
right. So one of the things, and Mike talked about this today. We every week, Mike is like our savant with industry news, and Florida is going through a campaign right now trying to, get it for recreational. It's legal for medical, but not recreational. But one of the things they're advertising for it is and I hate to use this but as an analogy, but it's true, is like the lottery. Oh, the money will go towards the schools. So they're trying to put it towards these socially good causes, or at least what they're advertising it for. And I think Mike's point is very well taken. Like, who's going to benefit, right? Or question rather, and that's going to determine kind of where it falls, I feel. And I think Mike's absolutely right. Now, whether or not it'll go all the way off, I don't think so. I think it'll get close, but it'll come down to it'll be heavily regulated, both state and federal.
Wait, you think long term it's not going to get descheduled? That's new. You didn't talk about that in bed last night.
I know. I'm sorry, man. I you know what? Your commercial today on Florida, their little thing, it really got me thinking. It's like, it's too good of a thing to get money from. And just like cigarettes or tobacco and alcohol, I kind of put it in line with that. That's deregulated, obviously, or not scheduled. But I see it slowly happening. I hope I'm wrong. I do. I hope I'm wrong. But at the same point, again, it goes back to what you said, Mike. Who's going to benefit? And as you think about that, that's going to really drive, I think, bureaucracy and policy.
So actually, Brian, this is actually probably a good way. It's a composite of our future. It's not our future.
Yeah.
But the hemp-derived space of cannabis.
Yeah.
They're basically living in a realm that essentially is not rescheduled, but never been scheduled whatsoever by virtue of ago. So right now, as we speak, you can go into a gas station or any kind of local tavern that sells top shelf, what have you.
Yeah.
You get access to beverages and products that have THC in them. They have cannabinoids in them. And again, it's some of these businesses have become fabulously wealthy overnight, drop shipping products to people with really no qualms about how it gets there, right? So they're selling confectionery gummies that don't entirely skirt the law, but do it at the same time. It's a gray area. The interesting thing about our pseudo sister space on the hemp side is that they're living in our future, except we know, and they sort of know as well, that it will be prohibited back. In our realm, as we progress forward, states are saying yes and creating a framework by which we operate. The hemp-derived space has basically built it to ask for forgiveness later to see how far they can take it, despite the fact that they know that there's no quality control overlap. There's no real control mechanism for their side of the space.
Right.
So the hemp space lives in our future today. The only difference, though, is they might be prohibited and already have been prohibited slowly but surely. Louisiana, for example, just said that hemp-derived products specifically are not permissible. So it's odd as it sounds, we already have seen the future and it's happening today.
Yeah.
Except that future can't, in its current incarnation, might not be able to survive. So I think collectively, because of the hemp debacle, or however you want to phrase it, I think collectively it's going to be viewed as one and the same. I think long term it's going to be rescheduled. And I don't know if you have children, but like my youngest is 10 months. When he's 21, it will have always been there. I think by the time he's 21 and of age, whatever the hell that means anymore,
Yeah.
He'll be buying his THC infused seltzer right now. Like that chocolate bar.
My daughter just turned 1 over the weekend, so
There you
we're
go.
right around there.
Mine are gonna be picking my old age home when you guys are 21, so that's
Well, that's the interesting too, which is, about, change is constant. We're talking about
Yes.
non-competes. We're talking about the workforce development of America. We're also talking specifically about consumption of something that was not permissible and is now becoming much more permissible, right? And how do those things collide? I think what's interesting is this is it working itself out. These things are colliding and have ramifications back and forth, but ultimately cannabis will be much like anything else. It'll be part of the, societal fabric and all of that. It'll be purchased like anything else because it already is. You're in a market that currently permits that. Jason is one as well. I'm in California.
Yeah.
So, right there between us, that is a marketplace where our children or our children's children will have access, as far as I can tell. So I think it's a matter of time.
Yeah. That was fascinating. I'm glad I asked the question. I appreciate both of your thoughtful responses. That's great.
No, that's the geek out stuff.
Yes.
we love that stuff. We love that stuff.
That's the good stuff, because that's all, the abstract stuff. Well, Brian, thank you again for meeting us for today. I think we're going to use all of this information, I think.
Yeah.
No, it was a pleasure. Thank you very much for having me. It was great to talk to you guys.
Signing off, Mike Siebold. Again, Mike Siebold,
Desentz.
Brian Casaceli. Thank you, and stay safe. Take care.
Take care.
Hey, Brian.
Thank you.